I'm involved in a contested divorce, and all of the issues are at play. There are retirement accounts, there's a property, a home, a marital home, there's investment property, there are stock, bond, mutual funds, there's a business, there are multiple children. Everything is in play. This is almost like a law school test. If you have parents and you're married this length of time and the divorce lasted, let's say 10 years, let's say it's a 10-year marriage with a 5-year divorce. What do we base maintenance on? Well, there's a number of statutory factors and by case law. And child support, there's actually a statute governing child support. However, that statute goes up to $203,000. And if you earn an amount above $203,000, that's a discretionary amount with a certain set of factors. So everything's at play. And let's say the settlement should be $500,000. That would be the division of equitable distribution. And this number is higher than that, but for purposes of this conversation, $500,000. If you do the math and you factor it and you take a look at the law, so say there's $1 million in assets, $500,000 each. When is it appropriate? When is it productive? When does it make sense for the moneyed spouse, the one with the business and maybe has a higher percentage of future income, or not a higher percentage, but an actual higher future income possibilities? Does it make sense, in this example, for the moneyed spouse to overpay slightly, or maybe a lot, but to get finality, to get resolution, to get an end date to the divorce? And if you settle, it's not appealable. So it perhaps makes sense to overpay in some amount, an appropriate amount, so that you forego continued trial, waiting for a decision, and a possible appeal. This is the art and business of the practice of law. I'm representing an older person above the age of 70 that's getting a divorce. Now, I have a number of elderly clients in the field of guardianship or estate planning, contesting some aspect of surrogates court. But in this particular case, I'm representing an individual that does not want to be divorced. Doesn't want to be divorced, does not want to sell the property that's owned with the partner, doesn't want to move. So we have this friction, because when you own a property inside of a marriage, well, what can be done? A can buy out B, or B can buy out A, or A and B together can sell to a third party. But what happens when one person wants to sell? Well, ultimately, and this can happen for a young couple, it can happen for an old couple, it can happen for people with adolescent teenagers. You frequently get one spouse that wants the house sold and the other spouse would like to keep it and stay in there. There has to be a recognition that when a marriage ends, the circumstances and the factual situation that existed while you were together can no longer exist. And if you have any value home, $200,000 home, I don't even know that they exist in New York anymore, but $100,000 would conceivably belong to partner A and $100,000 to partner B, subject to taxes and payment and realtor. But even if you have $1 million home, subject to all of those expenses, well, how do you get out? You're close to $500,000. Possibly the only way to do it is to sell to a third party. But my client And my mission is to not sell the property because that's what my client wants. Or, in the alternative, buy out the other side. And that's some tact and negotiation and prayer. Well, prayer always helps everyone. Even if you just pray to your higher power.